Hi, good afternoon, folks. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. And this is our bi-weekly community conference call once in every 2 weeks. We answer the questions to the best of our ability. You would have heard the disclaimers when you logged into the call. Those disclaimers apply to everyone. That said, let's just make sure you guys can hear me okay.
The conference is now in conversation mode.
Guys, can you all hear me all right? Am I coming through okay?
Yes, I can.
Okay, good.
Yes.
Good.
Yes.
Very good. Thank you. Okay.
The conference is now in presentation mode.
As usual, we'll get started first with questions that I think are frequently asked questions. There's one question here that I will not be able to answer. That question has to do with political asylums. And I've done only one political asylum case in my life back in 1993 as a favor to someone. So I don't do political asylums, guys. Sorry. The first one is about changing jobs while I-140 is pending and there's a change in job title, etc. So I have my PERM approved. Can I still use my priority date if I transfer to a new employer before I-140 approval or an I-140 is in progress? And there is actually a written directive from the USCIS, and it should be in one of their memoranda as well as in their policy documents, which says that if on the date the I-140 was filed, there was indeed an intent to continue with the job on behalf of both the employer and the employee, and you change jobs, that I-140 can actually be approved. Once the I-140 is approved, the priority date becomes yours to keep. And it does not matter if the job title with the new employer changes from software engineer to business systems analyst, you can still carry your priority date. Let me give you an example of how your job titles and jobs don't matter in the priority date transfers. Let's say you have a double degree. You have a degree in medicine and you have a degree in information systems. And your previous job, let's say, was as a physician in a hospital, but then you got a very good job offer from a company who wants you to run their information systems, and you become a manager, a systems manager. Now, a physician and a systems manager have nothing to do with each other, but you can still carry the priority date one from the other. Okay, so no problem at all with the job titles, and the only requirement is on the date the I-140 is filed, there is an intention to continue with the job. Press *5 if you have a follow-up question on this. Press *5. Okay, I have one question from area code 224. Area code 224, where are you calling from?
Hello, sir. I'm calling from Chicago.
Yes, ma'am.
I understood. So my question was also, can I do a transfer even before the I-140 is filed? And even then, if there is an intention to join my old employer back, because it takes a long time, 10 or 15 years waiting, that is still possible that my old employer can go ahead with the filing of my I-140?
I would want it researched, ma'am. In my opinion, yes, it can be done, knowing the law as I do. But law is full of surprises. One should never, ever presume to know the answer without double checking certain things. In my view, yes, legally, you could be gone and the I-140 can still be filed, as you correctly stated, based upon an assumption to come back to that job sometime in the future. But that raises a practical question. If you intend to come back, why are you leaving now? And I don't know what your answer is. That's something you should discuss with your lawyers, but I'll give you an example of an answer that worked for us. Many years ago, and that case was also out of Chicago. I've never had this question asked, but I had a guy who had his I-140 already approved. We filed the 480. I'm kind of forgetting the facts a little bit. Oh yes, What happened was the I-140 was approved, and then he left the company, and he wanted to file a 485 through the old company while continue to work for the new company and join the old company only after the I-140 was approved. USCIS questioned my filing, saying, how can he be planning to come back? Why did he leave? Luckily, we had already thought this through, so we were able to demonstrate to the government that the old company, I don't know if you're a technical person, ma'am, but they were experts in one particular kind of software that was going out of style. That software was called JD Edwards. It was an ERP. But then he wanted to get experience in other ERP packages like PeopleSoft, Oracle Financials, SAP, and he wanted to bring it back to his old company. And that's why he had left. So we were able to win that case very quickly. In your case, the only practical answer I would like to seek with your lawyers, not with me today, how do I justify in common sense why I'm leaving? Okay.
Okay, that makes more sense. Thank you very much.
You're
and
welcome.
Also, I can get the EAD for my spouse using the I-140 if it is approved, right?
That is, if the I-140 is approved and it stays approved for 180 days. Okay, you can apply for the EAD right away. But if the I-140 is withdrawn before 180 days, government can refuse to issue the EAD. And they will definitely refuse to issue future EADs based upon that I-140. If, on the other hand, the I-140 stays approved for 180 days, all your and your spouse's rights are protected.
Okay, perfect. Sorry, one last question on this. So if my new employer also files the GC, if that's the form that can still go on, even if this whole thing is going on in parallel?
Absolutely.
Or it's going to cause a problem?
Absolutely. Yeah, you can have multiple green cards going. You'll be very popular with the lawyers, but there's nothing illegal about that.
Thank you so much, sir.
You're welcome. Good luck. Okay, let's move on to the next frequently asked questions. So this one is another interesting one about going to school. I-485 is pending, but the employer is paying for the school in MIT. It's just a 1-year degree. On receiving green card, do I need to discontinue my degree in between and immediately return? My answer would be, I would want you to talk to your lawyers, but my answer would be no, because this is a very special circumstance. And I think you can finish your degree and then come back to your old job. Okay. So in my view, there are no repercussions because there's a reason you're not joining immediately. Okay. *5 if you have a follow-up question on this. *5. Okay. There is a question. And this comes to us from area code 814. Where are you calling from, 814?
Hi, can you hear me, Rajiv?
I can hear you, sir. Where are you calling from?
I'm calling from Pittsburgh here in Pennsylvania.
Okay, go ahead.
Yeah. So my question was, so if my 485, if I get my green card during my studies, I can just hold on to that and come back after 6 months or whenever I finish, maybe within a year.
That, in my opinion, in my opinion, should be okay. But I do want you to talk with your own lawyers who know all the facts of your case. I don't think it's a problem.
Okay.
Okay?
Okay. All right. Thank you, sir.
You're welcome. All right. Next question. Changing employers after I-140 approval. Okay. Moving from employer to employer B with I-140 approved. Scenario 1. If employer A revokes I-140 and employer B files a new petition, I can retain the date. Does employer have to revoke I-140 or can that continue? Oh, absolutely. See, under the law, H1 has to be revoked, but there is no law that says I-140 has to be revoked. As a practical matter, if the employer files a lot of green cards, they might have to revoke because it interferes with their financial picture necessary for the green cards for other people. But if the employer has done only a few green cards or they're a huge company, they don't really have to revoke the I-140. Scenario 3, if employer A doesn't revoke the I-140, employer B files a new labor and I-140 petition. Would the previous I-140 be valid? Oh, absolutely. Priority date is not a perishable commodity. It is attached to you, not to a petition. So understand that concept. The I-140 priority date gets attached to you. Therefore, wherever you go, that's where the priority date goes. All your I-140 approvals remain valid. Third, if employer B files a brand new PERM and I-140 with the new priority date, and employer A is valid with the old priority date, what happens if the old priority date becomes current? Do I need to go back to old employer? No, because what is being transferred is the priority date, and you can transfer that to any petition. So let's say you have 3 green cards going, but you want to inherit the priority date of the oldest one, which you are entitled to. You can do so for B or C when the I-140 is approved without having go back to A. Use of the priority date does not require you to go back to the original petition. That would defeat the purpose of the transfer of the priority date, right? Is there a 1-year max limit rule on filing 485? Yeah, there is such a rule. I don't exactly remember what its contours are because we've never had to encounter it really. But there is such a rule. There is a time limit. If the priority date becomes current, you've got to file your 485 within a certain period of time. Your I-140 doesn't get revoked or anything. I-140 once approved is good forever. What does happen is that you may not have the ability to extend your H1 on a 3-yearly basis. I think that's the problem. But yes, there is an issue about the 1-year filing date. Okay, but it doesn't revoke your I-140. Star 5, if you have a follow-up question on this, star 5. Okay. Let's go on to the next frequently asked question, if we have any. Okay. It does not look like we have a frequently asked question. Now we'll go to the regular questions. I remind the person who had posted a question relating to political asylum. I do not know the answer to that. We don't do political asylum cases. Our question labeled number 3. Nev Vas. I'm a current green card holder since 2018. The name of the minor daughter, 17-year-old, was on there, and the intention was to get her a green card of her own before she turns 21. I'm not entirely sure, Nev, what you are saying, because there are plenty of gray areas here that I have no clue. I think what you're saying is this, and if I'm wrong, you may have to correct me. What you're saying is that she came with you as a derivative beneficiary. And basically, you wanted to get her either an N600 based certificate of naturalization once she's eligible. I don't know if she is, or you wanted to get her separate green card, the document, not file a separate green card for her, but just file proof of green card, which is the document. So that you can do at any time. I don't exactly know what the process for that is. So I'm a little bit disadvantaged here because I don't recall what the procedure is, but that's just a document. Having status and having proof of status are two different things. If you have indeed put her as a derivative beneficiary, I believe she should have gotten her separate green card, so I don't really know what's going on. A little confused here. Press star 5 if you're on the phone. Press star 5. Okay. So this one is from area code 919. 919, where are you calling from?
Hey Rajiv, I'm calling from India actually.
Oh, okay. Good for you. What's up? Tell me.
Yeah, so my question is, I already have a green card, and I had filed for her green card as well.
Hang on.
That at some point before she turns 20.
Hang on. When you say you had filed for her green card, do you mean that you filed for her under the family-based green card categories as a minor child?
Yes, that is correct.
Okay. And that case is already pending?
Yes, that case is pending, and she's 17 now, and as I understand, before she turns 21, I got to get her own green card.
Well, actually, it's a little bit more complicated than that. Are the priority dates backed up 2 years? How many years are they backed up?
No, the backup is actually I go to the consulate and it's available on demand. It's in about 6 to 8 months.
Then that's not a problem at all. And nothing that Trump has done or intended to do can hurt her. I can't think of how she's affected by any of these things.
There was a certain ruling now that any unutilized family rolls over into employment base, so that doesn't apply to us.
None of that is. I don't even know what you're talking about. But let's say that what you're saying is true, or if it were true, it still doesn't affect her.
Okay, that's clear. Good to hear. Yeah. Thank you so much.
No worries. Good luck.
Oh,
you're welcome. Mm-hmm.
Thanks.
Bye. Okay, so next question is from Rudraksh. Green card holder applied for naturalization. They completed biometrics in March. So how accurate is the processing date? Nobody can predict that. About his girlfriend, we haven't had any formal ceremony. We just met. For a fiance visa, there is no ceremony necessary. The intention to get married is enough. Okay? You must have met in person. That is required. There are a few exceptions to that, but there is no formal ceremony necessary. Can I apply for a fiance visa once my citizenship is approved? Yes. Is fiance visa the fastest way? Assuming that she doesn't qualify for anything by herself, yeah, I think so. I think fiance visa is the quickest way. And doesn't mean quick, but it just means quickest out of all the bad options. Will going to formal ceremony recommended? No, I don't think so. A local consultant said it takes 2 to 3 months or less. I doubt that. I think it is 6 to 9 months. I can plan to go to India once the restrictions are lifted and get engaged. I don't think that is necessary, Rudraksh. I don't know of any reason to do that. Okay? Just file the K1 once you've got your naturalization in hand. Okay? *5 if you have a follow-up question. *5. Okay. PO Box. This is question number 7. I had my EB2 interview a couple of months back. Received approval of supplement J. There is a correlation, but that doesn't mean your 485 is getting approved. It simply means they consider the two jobs to be same or similar, but it is necessary for the 485 to be approved. So if your supplement J was not approved, that could cause delays. But just because supplement J is approved doesn't mean you're going to get any expedites. I think, do they reject or approve supplement J before they work on 485? Normally, I believe it's the same time almost. If the supplement J has been filed sufficiently in advance, they would rule on that and then wait for the dates to become current. But if it's close enough to the date, they pretty much simultaneously work on it. But I don't see how they can approve a 485 without approving a supplement J. Okay. *5 if you have a follow-up question on this. *5. Okay. Question number 8. I'm currently on an H-1B which was set to expire in October 2020. Renewal obtained till 2023. I-140 is approved. Wife is on H-4 EAD. She's going to have a baby. Congratulations. And she's waiting for an extension and EAD approval filed in July. Current one is expiring in 2020 October. Can she go on disability leave before her H-4 EAD expires? Absolutely. Absolutely. See, I have always told people, in my view, unauthorized employment requires two conditions to exist. You are working and you are getting compensated one way or the other, whether it's benefits or money. If both of them don't exist, you are not engaged in unauthorized employment. So if you are working, not getting paid and working for a non-profit, you're okay. If you are getting paid and not working, you're okay. If you're getting benefits and not working, you're okay. Star 5. If you have a follow-up question, star 5. Tanya Krishna. Applied for my H-4 and H-4 EAD extension along with husband's H-1B. Husband was approved 2 months back. Got his extension for 3 years. No update on my case. Yeah, you should be thinking of a lawsuit. Feb to August is 10 months. Yeah, I think at this point you can file a lawsuit. Yeah, I would just sue. That's what I would do. You can ask for an expedite. That would only help your lawsuit more. If you Google USCIS expedite criteria, a page will open up that shows you how to get your case expedited. Okay. Star 5. Star 5 if you have a follow-up question. Oh, one more question. In my case, my I-765 is approved. Do I have to wait until I receive the EAD card to start working? Wasn't there an announcement from the government today that because it's taking time for them to actually produce the documents, you can start working with 765 approval? I'm pretty sure you can. Double check that. Let's see. There is a question from our neighborhood, 703. 703 Virginia, go ahead, please.
Hi, thanks for taking the question.
Yes, sir.
So case was regarding my wife.
Mhm.
The question is, you mentioned a lawsuit can be filed because it's already been 6 months.
It's been more than it's February to August. Yeah, it's what?
Yeah, it's more than six. It's more
Right.
than 6 months, and their normal time period is 5 months for I-765.
Yeah.
The max time period.
Yeah, but do make a request to transfer. That helps you in the court also.
I didn't get you, sorry.
So make a request to the USCIS to expedite. That helps you in court also. Because
so when you say expedite, is there a specific criteria to
I just
application?
Yeah, I just told you. Google USCIS expedite criteria.
Okay. And you touched on something else as well. As far as I know, 765 applications once approved, people shouldn't be working unless
they changed that. I think they made an announcement. It was this morning, I think. They said because it's taking us so long to produce the cards, if you have a 765 approval, you can start working.
Okay.
It should be on USCIS website under the I-9 page. Okay. Look for that. Anything else?
So is there any other way that we can request or ask USCIS to expedite?
I just told you. No,
the reason
wait.
I'm asking
Wait, you're repeating the question.
time-
You're repeating the question. If you Google USCIS expedite criteria, it tells you what to do.
Okay.
But you don't really need it because First, look at uscis.gov I-9. I-9 is the form the employer has to prepare, and the government has said you can prepare the I-9 with just the 765 approval. Okay.
Okay, thank you.
You're welcome. Mikey says, my family-based green card interview was scheduled in March. They postponed the interview. Is there a general delay in processing time? Yes. Should I continue to wait? It doesn't hurt to call USCIS customer service. My EAD expires in mid-December. You can submit extension request 180 days ahead of time. Almost 6 months, a little bit less than 6 months. So you should submit it now, absolutely. 3 months is the old rule, not 3 months, 90 days actually. Now it is 180 days. Okay. And also the new rule is, it's 3 years old now, but relatively new rule is that if you have filed your EAD extension before it expires, December, you can continue working for up to 180 days after expiration. So you have a grace period to continue working. You will be fine. *5 if you have a follow-up question. *5. Okay. Harita is number 11. I'm working for a company, has offices throughout the US. I'm in location A. My team is in B. My priority date is 2011 from the previous employer. Current employer is starting my green card process. My manager is willing to relocate me to location B. Well, first of all, Harita, you have not yet filed your green card. Okay? So, I'm not sure what your lawyer is saying and what you're hearing. I can't believe that a lawyer will be so dumb as to not plan for a job that can be relocated. I can't believe that. It has to be somebody who's completely dumb. And I can't believe that, because in my experience, most lawyers are quite competent unless they are starting out. And in that case, you better get another person to advise you. But the way this works is, if my job has any possibility of relocation, I will file that job through the corporate headquarters. Let's say my headquarters is in California and I'm working in New York. So even though I'm working in New York from their New York office, because I could be transferred to Minnesota or to San Francisco, I can file my green card through San Diego, where my corporate headquarters is. So the first thing is, they have not yet filed your green card. They can plan for it better. Second, if you intend to come back to location A, where your green card is filed from, it doesn't matter what you do in the meantime. You can go to B, C, D, E, and F and return after your green card is approved, or any time before that, to location A. And that's good enough. Okay. So if your lawyer is indeed not considering this, you need to change lawyers desperately, because that doesn't make any sense to me. So either you haven't understood what the lawyer said, or there may be something specific to your case, or your lawyer is incredibly dumb. Let him know that. Okay. *5 if you have a follow-up question. Area code 732. Where are you calling from?
We are from Virginia. Thanks
Yes.
for answering my question, Rajiv. We've been interacting with you for probably 10 years plus.
That means you are. That means you are very old, and that means
I am. I'm I've been following you for a while.
I've been doing this for 30 years. I still remain young, and you've gotten old. That's what it means. But
I'm going to come out of this loop.
Go ahead. Tell me what's going on.
Again, this is a new opportunity that has joined, and as attorney is definitely not the way that I intended. But I've been giving my ideas because I probably have more experience than him. I told him that, why can't you file in this location, and you have a shared equipment option that can be utilized to save the time came back saying that we need to have a fixed position open and all that. I told them, I'm a permanent employee. I'm already permanent employee.
No, these lawyers do not know immigration law. They may be very smart corporate lawyers. My God, get an immigration lawyer. Tell them not to try their hand, experiment with you. Get somebody who knows what they're doing. Okay. Feel free to.
I hope I have that possibility to do this.
Yeah, no. Please tell them to.
I think I got your answer.
Yeah. Yeah. Okay.
Thank you for doing that. Hopefully, I'll convey that message to them.
Yeah. By the way, that rule about filing from the corporate headquarters has been in existence, I think, since 1984. So, if somebody has even done a little bit of immigration, they would know about this rule. Okay.
Got it. Yeah.
Good luck.
Thank you.
You're welcome. Bye-bye. Okay, I think it's 1984, either 1984 or 1994. It could be 1994 because I started my own practice in 1993. And that rule was, I think, already in existence when I started. So I don't remember exactly. But it's been around for 30 plus years. Okay. Now, next question is from Facecar. He came to the United States as an F1 and spouse with 2 kids came after F2. He was having a secret affair with a US citizen and had a child out of wedlock. Oh, the asylum question. I am very sorry. I have no idea about asylums. You need to talk to somebody who can advise you better. I have no idea how the asylum affects this whole scene. Sorry. Next question number 13. Want to sponsor my dad for green card. Mom passed away a few months back. Do we still need his marriage certificate? I believe you do. Marriage is not registered. Just get a couple of affidavits from people who attended the marriage. Okay. That's what you need, Sandy. *5 if you have a follow-up question. *5. Okay. The next question from Chaitanya, I think, is too detailed for me to really answer adequately. And I don't do many of the form filings myself. I am concerned with, you can think of me as a system architect, not a coder. So I wouldn't know some of the answers that you're asking me. I can try. Does she have to file 944? How do we get her to pass a 944 test? Sorry, I have no idea, because that's such a huge question. Basically, there is no simple way to answer that. So you may want to get an appointment with a lawyer, and just maybe even a local lawyer where you are, and get them to help you with that. I can't really answer that question in the abstract. And yeah, she's not applying under 245I. 245I was a totally different section. So I can't help you fill the forms, but I can tell you that 245I was for people who were illegally in the US on a certain date. So it's not something that applies to people who are applying legally. And yes, once she files her 485, she can stay in the United States while the case is pending. And once you file the whole package, you don't have to do anything else except wait. If the government wants more information, they will ask for it. Just follow the instructions on the forms meticulously. Make sure you look at their website if there have been any changes. And that's pretty much it. *5 if you have a follow-up question. *5. Okay. And then Himanshu says, I have 15 days left in H-1B transfer, either to another employer or F1 visa. Is it safe to file 2 petitions with 2 different employers, you mean, in 2 different projects? Absolutely. If both are denied, then you are out of status. You will have to leave USA rather quickly. So I would say normally I think it's within 10 days, but somewhere in that neighborhood. So if both, you can file multiple applications, but if all get denied, then you have to leave and come back on another H-1B from somebody else. Star 5 if you have a follow-up question on this. Star 5. Okay. And this is the last posted question for today from Sandy. Sandy says, working for employer A on H-1B till May. H-1B is good till 2023. I joined a new employer B on the receipt number. Employer B submitted an RFE response. They've denied the transfer. Employer A has already withdrawn my H-1B since I no longer work for him. So yeah, I think you are accruing unlawful presence. Yes, you are accruing unlawful presence from the date of the denial. You should have your lawyers look at the possibility of filing a lawsuit against the government. If they are refiling the H-1B transfer petition, really you need to, this is not something I can state in the abstract. Keep track of the 180-day unlawful presence that begins from the date of denial of the RFE response. If you don't get a decision within 180 days, make sure you leave. Otherwise, you'll be subject to 3-year bar. Otherwise, you can try refiling and try arguing with the government that this case should be approved. File it premium processing. And of course, if the second transfer gets approved, you're okay. But keep track of the 180 days. Could we file my second petition with employer B on nunc pro tunc? Yeah, you could if it's the same case. C can also file. They can file, but chances are if B is not approved, you'll have to go outside for visa stamping. Unlawful presence begins on the date your employer B's RFE response was denied. Can I change to H-4? Yeah, but not from within USA. If you don't incur 3 years 3-year bar, that is the 180-day thing, you'll be okay for the green card, no problem. So I think lawsuits should be very seriously considered. That's what I think. We've had tremendous success with lawsuits. I'm not a litigious person. I don't like people to sue for nothing. But there have been so many stupid denials. We have settled 100% of our cases. We filed so many of them in the last 7-8 months. So yeah, have your lawyers talk about what kind of lawsuits are possible, what is the denial. Because often that's the shortest route and the most dependable route to get your status taken care of if the government has been high-handed. Star 5 if you have a follow-up question. Star 5. Okay, folks, I've got 20 more minutes. We can do new questions. So I've got somebody from area code 570 who just raised their hand. Area code 570, are you Pennsylvania?
Hi Rajiv, good afternoon. How are you?
Good. Are you calling from Pennsylvania?
Yes.
Okay. What can I do for you, sir?
Actually, I'm hearing sometimes like there will be in future like some merit-based green card is going to come by the Trump administration. So in that case, if it is going to come, so like what will happen for the people who already filed green card and waiting in the queue for a long time? So all those people will be in the same queue with the new people, or how do you think, and what is your thoughts on that?
Trump can't do anything by himself. It's Congress that has to do it. Trump has to sign on it. So Trump can't do anything. Okay? He can try to take away rights. He can't give too many rights. Back about, I think 6 or 7 years back, when Congress had enacted a radical, not Congress, just the Senate. US Senate had passed an 1100-page bill, of which I read every single damn page, but it didn't pass the House. they had made plans for coexistence, if I remember correctly, of a dual green card pendency. So while the new process was being implemented, the old process would still go on. You won't be doing any more new filings under the old system, but the pending cases would not be disturbed. Okay. So
that means it will be like a two.
Yeah, it will be for a little while. It will be a two-track system where the old cases are still being processed under the old track and the new ones are being filed under the new track. One of the key things in the old law that they had passed at that time, which is probably going to be considered again, their concept was if you have a U.S. degree, a master's or a PhD, you should walk out of the school with a green card. Okay, that's the way the laws were written. And also, if you have a PhD from any country, if it is a recognized PhD, you should be able to get your green card very quickly. So that's the merit-based system they had prepared. There were some problems with that. It's been too long, I don't remember all the details. But it was a good system, I thought. Okay.
Okay.
Anything else I can do for you?
Okay, so that's kind of still in.
Nothing is going to happen for the next year. Nothing is going to happen unless Biden wins, Democrats take over both Senate and the House. You're not going to see too many changes. Okay.
Okay, and in that case, right, there is like a few green card availability numbers will be there, right?
Sir, I'm gonna have to move on to my calls if there are anybody else who has an immediate concern, because I really can't be discussing something that may never happen. So I'm not gonna write a fiction story here because I don't know how it's gonna play out. If things happen, we'll talk about them, but they're not gonna disturb your existing green cards. They cannot. Okay? I gotta go.
Okay, thank you very much.
You're welcome. Folks, anybody has any question, press *5. I've got 1, 2, 3 people raising their hands. 4. Okay, we'll call the number at 4, and that would be the end of it. All right, let's begin with area code 732. 732, did I just finish with you, or this is a new question?
You did finish with me. I'm sorry. I forgot to ask one question earlier regarding the question number 11.
Okay.
Imagine that the location is not a corporate location, not a headquarters. Can they still file it?
Yes.
From that location?
If you intend to come back to it upon receiving your green card or before, yes, they can use any location. Okay.
Okay, perfect. That's all I have. I just need clarification on that. Thank you.
Good luck. Okay, let's go on to the next one. This one is area code 517. 517, where are you calling from?
Hello, sir. I'm calling from North Carolina.
North Carolina. Okay. Go ahead, sir.
Thank you for being such an inspiration to serve the community. Really, I want to say this one. This is regarding the second extension for I-94 for business visa, B2 visa for mothers. So you have actually responded me this morning. Thank you very much.
Okay.
Just a follow-up question. When I'm filling the second application, I should still put the first 6 months I-94 expiry date.
Yes. I can't help you fill the form once again. I can't help you fill the form, but I can tell you this, that she has only one I-94 and that's the only one you can use. But because she has an extension pending, I don't know if you can put a cover letter. You can put a cover letter, right, when you file online?
Yes, there is a written statement you can attach.
Yeah, and you can put the receipt number of the pending case in there too.
Right. So when I submitted for the first time, the written letter was submitted. Rajiv C wrote the letter to USCIS.
Yeah, that's how it should be.
Can I write myself?
No, you are no one in the case. You are no one in the case. It's her case.
So she has to still write, but she can still say that my son will take care of everything and all that.
Absolutely. Right? And if you want to give a letter in addition saying that, as my mother has said, I will take care of everything, you can add that.
Oh, I can also support
Oh yeah.
another.
Oh yeah.
Yeah.
Absolutely.
Yeah.
Absolutely.
Sir, the health insurance, as I don't know how many months that I'll look for the right time to send her back. But I'm asking till end of February in this application.
Okay.
So do I have to have a health insurance till end of February to show that?
No, I don't think so. They will send you an RFE if they want more information from you.
Yeah, I'm planning to get it till December, and then if he's still here, then I will extend it. That's what I was thinking.
Yes, sir. That should be fine. Okay.
And the India return ticket, I can just show the previous India return ticket without being rescheduled because
I think so, because we live in unprecedented times. When you have so much unpredictability, how can you show a return ticket? Okay.
Right.
That should be okay.
Yeah.
All right.
Thank you very much.
You're welcome. Good luck. Okay. Let's go on to the.
Is there any
Sorry.
People can apply for second term, right?
Yes, they can.
Right?
Yeah.
At least in this situation.
Yeah, they can.
Okay.
Good luck.
And I have to still pay the money again, second time.
You have to keep paying the money every time. Yes.
Okay.
All right. Good luck.
Thank you, sir.
Okay, so who's next? This is area code 612. 612, where are you calling from?
I'm calling from Minneapolis.
Yes, sir.
Yes, sir. Actually, I applied. I could not find the job. I lost my job in COVID, and it's almost 60 days. And I applied for the B1 visa.
Okay.
And I received the receipt notice.
Okay.
So it's me, my son, and my wife. So
Okay.
I have a question that can my son go to the school? He goes in the public school.
That's something you have to discuss with the school. Okay. I'm not sure exactly how it works. I've never been quite clear on that. So I really don't know the answer to that. What I would do is I would ask the USCIS. It doesn't hurt. Make a note of the answer they give you and also check with the school. But start with the USCIS first. Okay.
Yes.
And another thing you can another thing you can do is you can also check with your local congressman's office and see if they can find out the answer. Okay?
All right.
Good luck.
Thank you.
You're welcome. You're welcome. Okay. So let's go on to the next question. This is area code 261, Pennsylvania. Pennsylvania, go ahead, please. Pennsylvania, go ahead. Oh, let's try again. Pennsylvania, go ahead, please. Hello? Pennsylvania, 261. Sorry, 267. Area code 267.
Hello.
Yes, go ahead.
Hello, Rajiv sir. Thank you so much for receiving my call.
Yes, ma'am.
Actually, I have discussed my case earlier also with you.
Okay.
Right now, I am in India,
Mhm.
and my question is, came to US on a student visa, and then I have completed. I've completed my masters, and then I applied for OPT.
Mhm.
I've completed the 1 year my OPT, and then applied for STEM OPT.
Mhm.
When I have applied for STEM OPT, I got denial on my STEM OPT because my DSO forgot to put the STEM OPT recommendation on my Zavis account.
Right.
And therefore, I have applied for MTR.
Okay.
I tried each and everything.
Okay.
DSO and PDSO gave me a letter
Okay.
stating the fact that everything, it was a mistake on their side and it was not at all my mistake.
Okay.
And that denial also denied.
Right.
I mean, sorry, that MTR also denied.
Yeah, I was expecting that.
So
I think you spoke with me, didn't you?
Yes.
Yeah, I didn't think you were
And-
gonna win, but yeah.
Yeah, but then I was not left with any other thing,
Yeah,
and
sure,
I
you
have
had
to
to
come
try.
back to US.
Okay, all right.
Oh, sorry.
To India. No, I got that.
Yes.
I got
And
that.
eventually, yeah. And meanwhile, I have came back in the mid of the June, and then I got a job here in India.
अच्छा जी.
I was trying to reach to my DSO and the PA DSO and the director of International Center,
Mhm.
and I was trying to ask, them, is there any way you can help me or compensate me or something like that? Because it is not at all my fault.
Oh,
And
hang
whatever
on
happened
one
happened
second.
because of
Hang on one second. There was an interesting lawsuit a few months ago where a student sued the school for screwing up their OPT, and the judge said the case can go to the jury. The school tried to get the case dismissed, and the judge said no, the jury could find you liable. So it could be a lawsuit against the school. Okay.
Yeah, and I really want to proceed in that way because I mean I have a huge loan, student loan, and life here is not so easy.
Mhm.
But yeah, I don't
Where
expect
is
coming back to
where
India.
is your school located, man?
Missouri,
Yeah, so you need to get a Missouri.
Columbia,
You
Missouri.
need to get a Missouri lawyer, okay, and
Okay.
tell them that there is actually a lawsuit filed. I think it's it's a federal lawsuit. There was a federal lawsuit
Okay.
where a student had sued, and the court declined to dismiss the lawsuit, and it proceeded to the jury. So in other words, this lawsuit is possible. Okay, so talk to a lawyer in
I
Missouri,
mean, so
to a litigator who can help you out.
sure, definitely I'll do that. So if I'll proceed in this way, there is I mean a big chance that I can win.
I don't know about the big chance part. There are too many variables. Plus, I'm not admitted in Missouri. I don't know Missouri law. You need to talk to a local lawyer,
Okay.
but it certainly is possible. It's not something I would dismiss out of hand. Okay.
Okay. But to you and having a consultation with you will not be helpful because I
No,
have to go and talk to
I will
Missouri
not be
lawyer,
able
right?
to. I will not be able to give you any opinion on Missouri law. It will be unethical for me to do so.
Okay,
Okay.
sure. I'll do that. Thank you. Thank you so
You're
much
welcome, ma'am.
for your
You're
help
welcome.
and
You're welcome. Good luck to you. Okay, let's see. We still have one more question left. Area code 517. 517, go ahead, please.
Sir, I have been hearing the fee has changed for this I-94 extension. Do you know about that?
Yes, I think fees are changing from October 2nd. You can double check that, but I believe it's October 2nd right now.
Oh, is it? Okay.
Yeah. Okay. And actually, the best source of most recent information is the USCIS website. Whatever they put on their website, they have to abide by that. They can't change that.
Right.
Okay.
Okay.
Good luck.
Thank you.
Good luck.
Yeah.
All right, folks, we're done for today. Thank you very much, all of you. It's good talking with all of you, and I'll see you again in 2 weeks. Always a pleasure to be here with you. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.